very much, Chairman, to you and your committee and to the Secretariat for this invitation. I am really happy and excited to be here, and I'm hoping this little material which I bring today will be of a bit of help to you and your members. So I come from IOSCO, and it's a county in the US, but that's not where I come from. I come from the International Organization of Securities Commissions, securities as in financial markets. And what I will try to do in the next few minutes that I have with you is I will try to explain what is the IOSCO Multilateral Memorandum of Understanding on Cooperation and the Exchange of Information. What is it? What does it cover? And then I will try to tell you why I'm here today, why we think it's been a success story, and I will try to share with you as well some of the obstacles that we have encountered through the time and that we think we have tackled okay. So first of all, as for IOSCO and what do we do, I was saying we are the primary securities regulators forum, and for that sake we have 150 securities regulators around the world covering, all the major markets regulators are included, covering more than 95% of the world industry, and we are basically the standard setter. So that's basically our business. And the reason I am here, I was saying, is because in 2002 we approved the Multilateral Memorandum of Understanding on Cooperation, Consultation, and the Exchange of Information. And since then, we have been very intensively working on cooperation and exchange of information with our members. Personally, this is a personal opinion, but I think it can be shared with many of our members. We think our instrument has been a success story. And I just want to leave you perhaps today with one indicator, and this is if any of you can have a guess of how many times we have used the instrument, if anybody or the chairman or...
It's not 70 billion though, right?
How many times do you think we have used the instrument since 2002 until today? Amongst our members, 150 securities regulators. 5,000. Okay, so multiply by 9.
Wow. And
you get the figure. So, so basically we collect statistics of the usage of the IOSCO MMoU, and our members in all, since its existence in 2002, have used the instrument for more than 45,000 times. So this means there has been more than 45,000 exchanges of information amongst our members. What does this imply? What does this imply? Of course, a lot of work. We cannot deny that. It's obvious that there is quite a bit of work more for the members, but the question is it worth it? And when you talk to each of them, including the largest users, they all say definitely worth it because it allows us to do our work properly. So that's the point. They tell the Secretariat, they tell the rest of the world that many of their important enforcement cases have been cracked because of information that they have received from elsewhere in the planet. And I think that's the really interesting note. Mm-hmm. So I was picking up on one of the chairman's questions from one of the previous presentations, and I don't have the answer to how many of those cases have been successful. Unfortunately, I cannot answer that. But I can tell you that in the old days, in our statistical collection, we used to ask a question about was the information received helpful to your investigation? So I can tell you as much as that. And I could say, talking from memory, top of my head, that around about 80% of the responses said the information received was very helpful for my investigation. my figures are top of my head, so allow for some. So with that, we thought it was really worth working with this instrument, continuing our efforts, and so on. So at the moment, we have 126 signatories out of the more than 150 members. We are still working with 27 who have not met the standard yet, because I will tell you later this is a standard. And we started working with our members, as I was saying earlier, in 2002. So the question, the very interesting question is, why do we need a multilateral cooperation instrument? And why do securities regulators nowadays, they tell us that they could hardly function without this instrument? Well, basically, they tell us that they are not islands as regulators. Working in an island, like in silos, geographically speaking, is a very old-fashioned way of working. That they tell us that most of their cases have ramifications in many parts of the planet. Securities markets are global, and therefore business is global, and therefore what typically happens is that wrongdoers operate in a mirror fashion. They operate globally, and therefore to get grips of the cases, they really need to be ahead of the wrongdoers and exchange information in a faster and speedier pace than the wrongdoers. So we have always recognized that there is an increasing internationalization of business, and in particular in financial markets, and that this was the route and the way we were going. So I think in the next two slides, we basically summarize why is cooperation important. So what is our instrument about and what isn't? Well, securities regulators around the world, some are part of governments, but most of them are independent. So I will tell you that, what it is, which is basically, nowadays we talk about this multilateral memorandum of understanding as the global benchmark for international cooperation in the enforcement of securities markets and securities regulation. So IOSCO has always been in the business of cooperation since our creation in 1983. But at the beginning, most of the cooperation was based on resolutions, so it was very, very voluntary, and also many bilateral MOUs, and members were kind of going crazy because IOSCO was becoming bigger, and there were more and more bilateral MOUs. The MOUs didn't end up with a level playing field because they all had different sets of rules, different sets of, for example, confidentiality standards, and they were not really operational and efficient enough. So we ended up with this international standard, which is not only recognized by IOSCO, but as well by the IMF, the World Bank, when they do their financial sector assessment programs and they look into the securities field, they definitely ask if the regulator has signed the IOSCO MOU. And in 2010, the organization made it compulsory to be part of the operational members of IOSCO, so to be able to vote, to be able to have a say in the organization, to be part of the policy committees, to be chairman of a particular committee, you need to sign the MMOU because you need to have demonstrated that you have that level of cooperation and that you have been examined to be able to sign that standard. Now, I can tell you also that that our MOU is not really a treaty because most of our members are not governmental. Some of them are quasi-governmental. Others are more have less of a governmental angle. And in theory, there are no legal obligations imposed, and it is not legally binding. So it's more like a gentleman's agreement, so to speak. And I would say,
just not in the antitrust competition context, just to be very clear here, there are a lot of antitrust enforcers on gentlemen's agreements, so we're just a little antitrust humor, sorry.
So what does it cover? So quickly, I will say that it talks about the scope of the assistance, focusing mainly in the area of enforcing securities regulation around the world. It talks about how to make a request for assistance and how to execute it along the lines of the tax area. You have to have a reason to send the request for assistance, and you need to explain what is not confidential of your case for the other regulator to handle it properly. It talks about the permissible uses of information, which is quite important. We'll say a few words about it. And there is an important section, by the way, Chairman, on the confidentiality requirements. So this MMoU is also a standard on confidentiality. You need to pass the exam on whether you are able to keep the information that you receive confidential. And then there is a reference to the concept of unsolicited assistance, because talking about the types of requests, regulators that sign can either send your typical request for assistance when they're dealing with a case, they encounter a ramification somewhere else in the planet, and they write to that regulator. But they can also, they are obliged by signing this MMoU when they are doing their own work at home. If they see anything which refers to another regulator signatory to this MMoU, they must send that information abroad so that the other regulation is aware that something which is happening in their own home. And they tell us that very often investigations start with what they call the unsolicited assistances. Well, I will say that what does it mean to be a signatory to our MMoU? Well, it's basically a statement of a securities regulator's commitment with regard to mutual assistance and the exchange of information for the purpose of enforcing and securing compliance with the laws and regulations of the relevant jurisdictions. So basically, if you sign the IOSCO MMoU, you make commitments in 5 important areas. First of all, you're telling the world that you have the ability to obtain information from another signatory, whether or not the violation being investigated abroad constitute a domestic violation. Second, you tell your fellow regulators that you're able to compel relevant information from any person, whether regulated or not. So what we call in the IOSCO jargon, from the pizza delivery guy, and also both from natural persons and from companies or legal entities. Third, you're telling the world that you have the authority to reconstruct any securities transaction happening in your country fully, including banking records, including brokerage, all kinds of brokerage information, and including information on beneficial ownership. And fourthly, that once you have that information collected, all that information collected, you have the powers to transmit that information to another signatory to this MMoU. And finally, you have to demonstrate a certain level, a certain quite high standard about your abilities to keep the information that you receive confidential. So those are the 5 areas, very high level, where you make the commitments. A very specific question that the Secretariat wanted us to cover. Well, typically, we have a specific article on the uses of the information, and we will typically use the information on administrative enforcement actions and civil proceedings. But regulators will be able to assist as well the prosecutor on criminal matters. Anything outside the securities field, the financial markets field, that a regulator wants to use that information that they have received under the MMoU for, they will have to go back to the originator of that information to ask permission. So it has, like in the tax field, a very specific purpose. After a few years, we developed a further an enhanced standard because we realized that there had been advances in technology and other areas had not been covered very specifically in the initial MMOU, and we established what we called the enhanced MMOU. This is, so to speak, a higher standard of cooperation, where we say that if you are able to sign this document, this agreement, you need to demonstrate that you are able to exchange audit papers, that you are able to compel physical attendance for testimony, that you are able to freeze assets or help freeze assets, and as well to obtain existing internet and telephone ISP records. This is as I was saying, much higher standard, and therefore, at the moment, it has only been signed by 22 IOSCO members. Now, I want to very briefly tell you why I personally think that IOSCO is really the MMOU is really the flagship of IOSCO, and it has been a very successful story. So, as I was saying earlier, it's really a standard, and therefore it's a mark of credibility for a regulator. Our members are kind of very proud of being part of this multilateral arrangement. Now, it's not easy to sign the IOSCO MMoU. I mean, I have to tell you, I have lived through many, many stories. Some of our members have taken up to 15 years to access the IOSCO MMoU. They have been examined several times, and they have failed to pass the mark of the MMoU because of the standard it implies, including on the confidentiality side. So the most difficult part to pass is obviously the banking records and the fact that not all of them were able to obtain banking records from any member, and the unregulated the need to demonstrate that you can go to any person in your country and, if relevant, obtain information from them for an investigation elsewhere in the planet. So we have a screening group, which is a technical group with no political interference in IOSCO, and they really go through the screening of the cases very seriously, and this has given us a lot of importance to the actual exercise. There is a very kind of serious monitoring as well on the application of the MMoU. So every year we issue a survey. We ask all our signatories, have you encountered any difficulties in cooperation? Tell us about the cases. We will follow up the cases, and we have a dedicated group just following, doing the monitoring. I think I already mentioned that the MMoU was made compulsory after a few years of its existence, and also that sanctions were imposed on the members by 2013, and they were kind of de facto expelled somehow from the core business of the organization if they had not signed the IOSCO MMoU. Now, in parallel, we recognize that for some of our members, changing legislation just to sign the MMoU has impacted tremendously on them. And we have developed a very intensive technical assistance program, and we have given political advice. We have visited many parliaments. We have spoken to many governments, and we have helped as much as possible. And finally, I just, if I have a couple of minutes, I'd like to share why I think there have, why there will be some important obstacles on the way, and I'm not sure why this is not working.
Becky, can you move the slides?
So, so the next slide. Thank you very much. Excellent. So, basically, obviously, these things take a lot of effort from organizations, and we needed to convince the key players about the vision of the importance of cooperation. Today, I think it's quite obvious that the world is so global. I mean, we are all seeing that one particular event happening in Europe, it's impacting the whole world and so on, but perhaps 20, 25 years ago, the vision was not exactly the same. Unfortunately, there was a key event in our history, the 9/11 events in the US in 2001, and the possibility, the potential of terrorist financing through the financial markets. And that really triggered a new way of thinking in our area and in our field of work. And that really gave us a very strong push for enhancing the importance of cooperation amongst our members. So obviously, to be successful, I think you need to achieve a critical mass. Some key members need to lead the way and do by example, so to speak. And then there is the very rigorous screening because of the level playing field. I mean, if you end up with an agreement of this sort, everybody has to have the same level of cooperation, and it cannot be a cooperation a la carte. You know, it has to be an instrument that serves equally to all the members, whether big or small, or important or less important. Because nowadays with globalization, you never know where the threats are coming, where the next risk is going to emerge. So you can't really discard smaller jurisdictions because of their economic importance, or it's really this global mind which has helped us. And also the commitment on rigorous monitoring that we were mentioning before. And I will say just a word on the data protection matter that colleagues were referring before. We had a big threat, in particular, when the European legislation came into force, the GDPR, because for a moment we thought that our instrument was completely at stake and that we were going to be unable. In particular, we have some Europeans who are very large users of the MMoU with obviously large financial markets. So what we did is we went to talk to the European Data Protection Board. We explained why it was important for us to continue cooperating and using this instrument. And we signed with them an administrative arrangement already a few years ago, which gives IOSCO members an exception for the purpose of enforcing securities markets regulation on the use of the data protection regulation. And this has been quite amazing because we were the first ones to sign this administrative arrangement with the European Data Protection Board. We just have an obligation to report back to them after every couple of years. And then my advice, this is really a long-term project, you know, and unfortunately, many of us are in some organizations for a short time, and we love to see immediate results, but this is more something that history will thank you for than actually immediately, you know. Talking about the main difficulties that we have encountered, I think that, you know, having to convince, I think, no less than 60 countries to change legislation to adhere to the MMoU. So with that, I will stop now, if I may, and I want to thank you very, very much again for this invitation.